webinar. I welcome all the participants who have joined for our today's session. We would request all the participants to keep themselves on a mute mode and also to keep their video off for the bandwidth issues. And also, if anybody has got any question, please send it to us through the chat mode. There is a chat option. You can type out your question there. And at the end of the webinar, we will answer those questions. With this, I would now request the Chairman of the Legal Committee of the Bengal Chamber, Sri Debkumar Mitra, to give a formal welcome address and begin our today's webinar. Thank you, sir.
Good evening, everybody. Welcome to the webinar organized by Bengal Chamber of Commerce and Industry on the law of force majeure and obligation to pay salary and wages during COVID-19. Now, COVID-19 outbreak is without doubt a human tragedy which has affected hundreds of thousands of people. Not only in India, but also around the world. Can I be heard? Am I being heard?
Yes.
Yes,
Loud
sir.
and clear. Loud and clear.
Okay. Now, the World Health Organization declared a pandemic on 11th March 2020. Thereafter, the government of India and followed by the state governments declared a nationwide lockdown effective from the midnight of 23rd March 2020, which has wreaked havoc on the economy as a result of supply chain disruptions and weakened business confidence, leading many enterprises to suspend their operations and let go their staff. The uncertainty surrounding the situation has led many to look for answers regarding what should be done to address various issues regarding contractual obligations, employer-employee relationship, and overall business perspective. In contractual relationship, there are two issues like the frustration of contract and force majeure. Those are very relevant in the present circumstances. To be able to effectively respond and not create additional disputes, it is necessary to understand the nature of the particular force majeure clause and the laws governing the same in India. The rights evolving from that clause also. The consequences of force majeure, if applied in the current circumstances of lockdown in India due to COVID-19 pandemic. The uncertain economic situation brought on by the COVID-19 pandemic and consequent lockdown has led to hard decisions by the companies cutting down expenditure, by downsizing their workforce and reducing or deferring payment of salaries. And understanding of applicable employment laws is the key in such times. Both central government and state governments have issued orders on 29th March 2020 to mandate that employers in all industries, shops and establishments must pay their workers during the period of lockdown. Both have relied on the Epidemic Diseases Act 1987 and the Disaster Management Act 2005 to issue directions to private sector. With these words, I would request Mr. Debkumar Mukherjee, our President Designate, Bengal Chamber of Commerce and Industry and Managing Director of Synergist Energy Private Limited, to kindly take over and proceed with the rest of the proceedings today. Mr. Mukherjee is an entrepreneur. He's a lawyer, first of all. He's an entrepreneur, over 33 years work experience in diverse business domains, engineering systems, information technology solutions, and energy services. Mr. Mukherjee, kindly take it over and proceed.
Thank you very much, Mr. Mitra, for your handsome words. And thank you also for giving an overview of the subject of discussion this afternoon. I know, picking up the thread from where you left, this wake of COVID-19 pandemic certainly has brought about unprecedented challenges and impediments in our business life. Now, in order to actually respond with an effective crisis response strategy, so to speak, and also to look at a wider recovery plan to bring business back to quote unquote normal, whatever be the normal that will now come about. Various aspects need to be considered. But two most important aspects that need to be addressed, as you rightly pointed out, Mr. Mitra, are discharging contractual obligations, one, and payment of salary and wages by employers to employees in the face of this lockdown, where business operations have practically come to a grinding halt with no production, liquidity crunch. And what is most distressing is the anxiety that the present situation has caused and the sheer uncertainty of it all. We have an array of eminent speakers, and I'm delighted to introduce them to you. We have Mr. Shamal Sarkar, Senior Advocate, High Court of Calcutta, and I'm told Mr. Sarkar specializes in infrastructure, regulatory, and labor laws. We have our own Mr. Shomesh Dasgupta, Group President of India Power Corporation Limited, and the Chair of our People Management Committee, representing business. We have Mr. Probal Kumar Mukherjee, Senior Advocate, Calcutta High Court, specializing in civil and constitutional matters. And correspondingly, we also have Mr. Prakash Panda, Senior Vice President, HR from India Power Corporation Limited. It's also an honor to introduce Mr. Jayanto Mitra. Has Mr. Mitra joined the webinar?
Yes, sir. He is right now joining the webinar. We can see him, but he's taking some time to put on the audio.
Okay, right. So maybe I'll again welcome him a little later as we progress into the deliberations. So Mr. Mitra, Barrister at Law, Senior Advocate, High Court of Calcutta, also happens to be the former Advocate General, Government of West Bengal. Apart from Mr. Mitra, the chair of our legal committee, the vote of thanks will be proposed by Mr. Paritosh Sinha, co-chair of our legal committee and a senior advocate of Calcutta High Court. So a very well-balanced set of speakers. The way we are going to play it out this afternoon would be each of the speakers will speak for about 10 minutes. And they would speak on these two issues, but just to bring a little more focus into the deliberations, maybe I will set a few pointers before I invite the respective speaker, which could bring the interaction and the deliberation into focus and make it more meaningful to all of us. As Mr.
Good afternoon, this is Gautam Mitra. Now I am joining this webinar.
Oh, Mr. Gautam Mitra.
Sir, he's from the Chamber Secretariat.
Oh, I see. Oh, I see. Okay. But is he also participating in the deliberations?
No, see, he's joined us as a participant of the
Okay,
group.
okay. Thank you. Thank you, Sukanya. As Mr. Dian Mitra pointed out very rightly, the government of India came up with this order by the empowered group as part, I would take it as a disaster response plan under the Disaster Management Act, which talks about payment on no reduction or in payment of wages to workers and laborers in any organization. Now, as a pointer, this is not just a question of a legal obligation. Mr. Sarkar, you would be the first person to actually talk on this. But here, there is also a larger moral issue I can see coming up, because it is as if there is the legal obligation and there is the moral obligation. Now, the first question is whether this legal obligation, which has been enforced by this directive, whether this can actually stand the test of law if challenged. But going beyond that, I have a more fundamental question, and I would be really happy, Mr. Shafkar, if you can throw some light on this. The question is whether rights of citizens, the right to fair wage, right to a fair earning from a contractual obligation, the rights of citizens and obligations of a state in this sort of a pandemic, can that be assigned actually to a private establishment under the Disaster Management Act? In short, can rights of citizens and obligations of a state be assigned to private companies or to private establishments? And more fundamentally, to what extent, if I may ask you, sir, can legislation interfere in the conduct of men, so to speak, the businessmen? I can understand that morality will drive certain actions that legislation cannot enforce, though larger objectives may be the same. But to what extent can legislation or orders, executive orders under some legislation like the Disaster Management Act, be enforced upon private organizations? Over to you, Mr. Sarkar, for your views on this aspect.
Thank you, Mr. Mukherjee. I hope I'm audible.
Yes.
Yes,
Yes.
sir.
Now, I have noted your points. You say that there is a moral issue and there are legal and moral obligations. Next is whether this the direction order 29th March by the another Disaster Management Act that can stand the test of law, and whether the right of citizen or obligation of the state it can be entrusted to private companies. In other words, whether legislation can interfere with the functions of private organizations. These are where broadly your question points. I'll definitely address, but before that, let me make clear. I will group my. I'll first start with the centuries-old saying by John Sheldon that this is answer to your moral and legal obligations. John Sheldon said that law and justice, they are not cousins. They are not even distantly related. They stand poles apart. So, as a lawyer, I will make my submissions here restricted to law only and nothing else and nothing more. So coming, as I said, I'll group my submission 4 heads. First is our whole obligation that nobody the salary has to be paid. Normally, employer-employee relationship is governed by contract, but here the state is intervening, saying that you cannot deduct any payment, you must pay on the due date during this lockdown. So whether this direction or order by the authority under disaster management, that is constitutionally valid, that will be my first submission. My second submission, and that will cover reduction pay, retrenchment, layoff, and leave management issues, all covered in that. Next, my question will be, even if this order is not there, our labor laws are very stringent. Whether under labor laws we can deduct wages, or labor laws, existing labor laws permits an employer to deduct wages, and to the what extent, because even if this notification goes, labor laws will stand in the way. My third is, what is the international scenario? And my fourth group will be whether the lockdown is an event of force majeure. So coming to the first issue, that whether this order, this is order number 40-3 2020 DM 1 under bracket A, dated 29th March 2020, issued by the chairperson, National Executive Committee, under the Disaster Management Act, under section 10 subsection 2 small l of the Disaster Management Act. So because, as we say, when you say a constitutional issue involved, we first say the ultra vires issue, whether it is within the powers of the authority who issued it. So for that, we have to see the Disaster Management Act. Now, Disaster Management Act, firstly, it says that
audio কি হচ্ছে?
Mr. Mitra, DN Mitra, can you unmute yourself? Unmute yourself.
Sorry.
Yeah, carry on, Mr. Shotgun.
Yes. So I'm placing the relevant portion only. Whereas to deal with the situation and for effective implementation of lockdown measures and to mitigate the economic hardship of the migrant workers in the exercise of powers. So conferred on section 10(2) small l of Disaster Management Act, the undersigned, in the capacity as chairperson, National Executive Committee, hereby directs state, union territories, state governments to take necessary action, necessary orders, and III of that directions comes, all the employers, be it in the industry or in the shops and commercial establishment, shall make payment of wages of their workers at their workplaces on the due date without any deduction for the period their establishments are under closure during the lockdown. This portion we are concerned for the present moment. So whether this order by the chairperson of the National Executive Committee under the Disaster Management under section 2, section 10(2)L is a valid piece of an order. That is the first issue. So we first go to sections 7, section 3, or the first we take the preamble of the Disaster Management Act, an act to provide for the effective management of disasters and for matters connected therewith or incidental thereto. This is the preamble, very short, and disaster management is also defined under section 2E, means a continuous and integrated process of planning, organizing, coordinating, and implementing measures which are necessary or expedient for prevention of danger or threat to any disaster, mitigation or reduction of risk of any disaster or its severity or consequences, capacity building, preparedness to deal with any disaster, prompt response to any threatening disaster situation or disaster, assess the severity or magnitude of any effects of disaster. These are the disaster management means. Now, section 3 of the Act defines National Disaster Management Authority, or it's called the National Authority. National Authority is the prime authority under the Act, which is to make Section 6 provides the powers and functions of the national authority to lay down policies and approve the national plan. Now, subsection 3 says chairperson of the national authority in case of emergency have power to exercise any of the powers of the national authority. Now, next comes the constitution of the National Executive Committee. Section 8 provides for Constitutional National Executive Committee. I am not placing them. Then the most important is powers and functions of National Executive Committee, Section 10, because power has been exercised under Section 10 of this Act. The National Executive Committee shall assist the national authority will assist the national authority in the discharge of its function and have the responsibility for implementing the policies and plans of the national authority and ensure the compliance of directions issued by the central government for the purpose of disaster management in the country. In other words, National Executive Committee has the power only to assist the national authority and to implement the policies of national authority. The policies has to be made by the national authority. Now, what does Section 2 says? 2 says without prejudice to the generality of the provisions, National Executive Committee may, L says, lay down guidelines of give directions to the concerned ministries or departments of the Government of India, the state governments and the state authorities regarding measures to be taken by them in response to any threatening disaster situation or disaster. I place this part. So it can implement any policy or guidelines or give directions to the state regarding measures to be taken by the state in response to any threatening disaster situation or disaster. Now, this direction not to deduct salary has been issued under clause L of this section. Now, any rules or any subordinate legislation or delegated legislation or notification or order under any statute can only be made in aid thereof and not beyond thereof. So, Section 2L provides measures in response to threatening disaster situation or disaster. This provision, my humble submission, does not empower. First of all, first limb is that the plan has to be made by the national authority. Here, this order doesn't say there is any plan by the national authority. So, executive committee is only implementing authority. An implementing authority cannot pass the parent order. It can only implement. The policy is to be made by the, say, board of directors of a company, and one officer is a recovery officer, an implementing officer. An implementing officer cannot make the policy of the company. Similarly, so, and next part is this is issued by the chairman. A chairman has no jurisdiction to issue any order. Now, on these two aspects, I'll refer to two decisions of Supreme Court. First of all, that in 1902 there was the Abkari Act in the state of in the southern states by the state of Mysore, which was adopted by the state of Kerala. In 1996, state of Kerala banned sale of arak, is a type of country liquor. Now, in 97, the act was amended, arak was banned, and corresponding provisions were made. After about 5-6 years, the state of Kerala issued a rules under that amended act, which said that one person who wants to get a license to sell toddy, which was not banned, must absorb one employee from the abolished arak shops. I repeat that that Arak shops which are closed, banned, one of their employees have to be absorbed by the persons who wants to take a license of toddy. That was challenge. Single bench of Kerala High Court says it is perfectly all right. It's a beneficial legislation for the workers. Division bench of Kerala said yes, it's a beneficial legislation. Then went up to Supreme Court. Honorable Supreme Court, it was presided, judgment was delivered by a very eminent jurist, we all know, Justice S.B. Sinha. He said that these rules must be in conformity with the parent statute. Now, and power of delegated legislation cannot be exercised for the purpose of framing a new policy, and power only to give effect to the provisions of the Act. Here, section 2L says where if there is a very alarming situation that is to be taken care of. Section 2L says the language is threatening disaster situation or disaster. Now, by paying salary, neither disaster can be restricted, or not by not paying salary, disaster cannot be expanded. It cannot be let loose. So this part was contrary to the scheme of the Act, or we say in legal words, these rules, this order of 29th May and the subsequent order passed by the respective state governments, they transgress the Parent Disaster Management Act, and hence is ultra vires and violative of Article 14 of the Constitution of India. This is one part. And second, this judgment I am referring to is in the case of Kerala Samsthana Chettu Toju Lali Union versus State of Kerala, reported in 2006, volume 4, Supreme Court cases 327. Second limb is, if there is a commission or a committee, the order has to be passed by the committee itself. However, the secretary or the executive member of the committee can communicate that decision, that committee has taken a resolution so and so, and by order of the committee I am communicating this order. But chairman cannot pass any order. That was also well settled in the cases of umpteen number of cases. Right. So, my summing up first point is that this order by the chairperson of the National Executive Committee under section 10 subsection 2L of the Disaster Management Act is ultra vires, or is transgress the Act, and hence ultra vires the Constitution of India. Therefore, but our Indian law says that no order becomes invalid just because it's illegal. One has to go to court to declare it illegal. So until someone challenges it before a court of law under Article 32, under Article 226 of the Constitution of India, or by a suit even, it is valid. But my view is, if it is challenged, it should be set aside by by a court of law. Now, if this goes, even then, does it empower the employees to deduct the wages? My humble submission is no, because our labor laws come into force. First of all is Factories Act says that chapter 8, section 78 to 82, which provides annual leave with wages, section 80 particularly says that worker entitled to wages equal to daily average of his total full-time earnings, and section 82 says unpaid wages can be recovered under the Payment of Wages Act. Now, this is under the, so far factories concerned. What about the establishments? There's our Calcutta decision reported in 1977, volume 2, Labor Law Journal 285, which says that so far wages is concerned, even under the Shops and Establishment Act, it is governed by Payment of Wages Act. So Payment of Wages Act is our only thing to be considered in respect of factories and also for establishments. Now, Section 3 of the Payment of Wages Act 1936 says that every employee is responsible for payment of wages. Section 7 of the Act provides the power of the employer to make deductions. Now, what can be deducted? Important is subsections 1 and 2 of section 7, subsection 2, subsection A and B, if there is a fine, or B, deductions for absence from duty. So if a employee is absent from duty, his salary can be deducted. This is a plain and simple language, but subsection 3 stands in the way. It says, I have to place it, notwithstanding anything contained in this act, so it's a non-obstante clause, subsection in any wage period from wages so and so is in case where the deductions wholly or partly made for payments so and so, in other case 50% of such wages. So no employer in India can deduct wages more than 50%. 50% wages has to be given. Now, what happens when a person is, say, absent after exhausting all his leaves for, say, 20 days? Even then I have to pay him for 15 days. No. The payment of wages says you have to pay 50%, but if you pay 50%, you will be paying 5 days extra wages to him. For that, the employer has to initiate a proceeding for recovery of that 5 days extra wages. But you cannot pay in no circumstances less than 50% of the wages. So this is the interesting part. But another thing is, important part is explanation to section 9, which says that an employed person shall be deemed to be absent where he is required to work if he refuses in pursuance of a strike or any other cause which is not reasonable to carry out his work. So a person who unreasonably refrains from performing his work, only his salary can be deducted. But in the case of lockdown, by no stretch of imagination, one can say that he has been absent without any reasonable clause, any reasonable grounds. But the most important is section 15, subsection 3. I don't know why it came, that it is an act of 1936. So possibly, correct me, somebody correct me if I'm wrong, before that or around that time, plague has hit the world. By plague, many people were killed. So plague has hit the world. So like a COVID-19 or SARS, possibly there was a situation in 1936 or before that. Therefore, there is a clause that no direction for payment of compensation shall be made in case of delayed wages. So if the salary for April I am paying after reopening in September, I need not pay any compensation or interest or penalty if the delay was due to, I read it, the occurrence of an emergency or the existence of exceptional circumstances. The person responsible for the payment of wages was unable in spite of exercising reasonable diligence. So emergency, existence of exceptional circumstances, in my view, squarely covers COVID-19. So if an employer he can negotiate with the employees and defers the payment. Say you pay some amount now up by negotiation, and you defer the payment after the factory reopens. This is permissible under the Payment of Wages Act, because this act is of 1936, and there must be some event, pandemic or event like COVID-19, because says of emergency or the existence of exceptional circumstances. So COVID-19, in my view, definitely falls under exceptional circumstances. So this is the labor laws is concerned. Now the other part is about international scenario. About international scenario, let us take the most optimum one, Austria. Of course, we could not get the data from all over the world, only few countries I can only say. Austria is the most optimum, which says that depending on the number of workers employed in an establishment or a organization, workers will get 80 to 90% from state, and the employer has to pay 20% or 10% as the case may be. This is the most optimum case I have found. This is one part. Now, in South Africa, they have brought out a disaster management tax relief bill to give a substantial tax relief to the companies or to organizations due to this COVID-19. And also the act, their bill provides that if the gross income is less than 10 M, their currency, the employer need not pay salary from April to July. I mean, not that they do not pay at all, but they have to pay a certain percent in May and the rest in September. So in other words, as our act provides, Payment of Wages Act, they have deferred. They have also deferred the GST payments. They have also deferred the carbon tax liability they have there. They have deferred. And I have also come across a research paper prepared by the Oxford University relating to impact of SARS. This was on SARS on human resources management in Hong Kong, which said that in April the employers were allowed to deduct 9.9%, and for May, June, possibly 2003, they were allowed to deduct 30% from the salary of the workers. But some companies, some hotels, they said that if you take leave without pay for 4 weeks, then at the end of the year, you will get a bonus of 15 days wages. This was.
If I can just interrupt, we are slightly running out of time.
I'm sorry. I'm so sorry.
In the next 5 minutes or so, if you can just wrap up.
Yes. I'm almost over. So this also, this University of Cambridge research paper, they also suggested a sort of deferment, and then America, not all the provinces. When SARS came, then ISO, the parent organization of institution of the insurers, they included a exclusion clause of epidemic exclusion clause in their business interruption policies. Now, New Jersey legislature has made a bill, has not been enacted, that even if there is exclusion clause, insurance companies have to pay for the loss suffered by a business entity under the business interruption policies. These are the international scenarios. And regarding force majeure, my view is clearly a case of force majeure. Force majeure means superior force, force majeure, superior force. Now, COVID-19 is definitely a force majeure. Lockdown is definitely superior force, no doubt about that. But unfortunately, in India, the law relating to frustration under Section 56 of the contract is very stringent. Is very stringent. In fact, after this COVID-19 have come across two decisions. One is by Bombay High Court in the case of Standard Retail Private Limited as GS Global, where Bombay High Court say no, this is not a force majeure, and another by Delhi High Court in the case of Delhi High Court in the case of Halliburton Offshore Services Incorporated Vedanta Limited, reported in 2020 SCC Online Delhi 542, where Delhi High Court held that this is a force majeure and granted injunction against enforcement of bank guarantees. So there are two contradictory views. There is no decision by Calcutta High Court yet. There are contradictory of Bombay and Delhi High Court, but there are three circulars actually by the government department saying that for government contracts, this lockdown period should be treated as force majeure. Now, this was by the Ministry of Finance. Then it was also by the Ministry of by two other ministries, Ministry of Shipping and also Ministry of Renewable Energy. But as such, these circulars will not apply to private persons, but definitely the logic should apply. In my view, this is squarely covered by lockdown. Those are my submissions. Thank you very much. I'm sorry for exceeding my time. Thank you.
No, thank you very much. Thank you very much, Mr. Sharkar, and making it very clear the correct position of the notification or the order, the executive order that came about. It's somewhat like placing the cart before the horse, because they were not competent to actually, they are only implementing agencies, but they are not the ones who can actually pass an order. So thank you for this, and also
Mr. Mukherjee, can I take 30 seconds, please?
Yes, please.
There is no circular yet, but in the Employees Provident Fund Organization website, they have published that Government of India will pay PPF contribution of both employer and employee. That's 12% for the next 3 months, so that nobody suffers due to loss of continuity in the EPFO contribution. That means already government is subsidizing 12% of the salary of the workers who are covered by the Provident Fund Act. And for this, government is spending about 5,000 crores for this purpose. That's all. Thank you.
Right. It's somewhat, if I may ask you, Mr. Sharkar, do we have this concept of furlough, putting employees on furlough, as we are doing in the UK and other countries? And do we have that concept at all in India?
Could you explain little bit?
That is, you are put on sort of in abeyance. You are not earning your salary, but your employment is still intact. The state pays you. For instance, in the UK, the state is actually paying about 70 to 80% of the salary. And then when the business comes to near normal at the right time, you are sort of re-employed, or brought back into employment, into regular employment.
No, sorry, we don't have in India. We don't have in India.
So that provision is not there. Anyway, thank you very much, Mr. Sharkar, for your exposition. May I now request Mr. Shomesh Dasgupta from the industry side, from the business perspective, to tell us about what is the wider recovery plan. Firstly, what is, sir, your response to the current situation as a business? What's the wider recovery plan? And how do you think you can take a balanced approach, looking after the interests of the employer as well as the employees in light of your organization? And what would be the good practice for other organizations. Being head of HR and the group president, I'm sure you'll be able to shed some really meaningful light on this. Over to you, Mr. Dasgupta.
Thank you, Mr. Mukherjee. I'm audible? Is this okay?
Yes, yes,
Yes.
yes, sir. Yeah.
Thank you for that, and Sukanya and Mr. Mitra for the excellent initiative having two subcommittees, legal and people management, coming together for an important topic to discuss. As a part of a person in the industry, more than 25 years of HR and IR directly, and presently managing the business of the organization, I have some response in this particular COVID-19. As you rightly said, the main complication of the COVID-19 is the uncertainty, because it's an unheard thing. Maybe last 100 years, nobody come across such a situation. So if you talk about any perspective, employee perspective, employer perspective, and as it is a people-centric problem, people management members also little confused about the window of the particular impact, whether it is for 15 days or it is 2 months, 3 months, 6 months, on the line. So the entire thing are lying in the complication of the particular uncertainty. So with that idea, my response is, as a member of a management leadership team, and also my experience from the people management front, as on today, the people management front, when they are working in this particular situation, like you said, in legal frame, there is a legal obligation or legal consideration. You also said on a moral obligation and moral consideration. I'm adding the third vertical, which is the business obligation or business consideration. So the entire thing, we have to think in this manner of business obligation or business consideration, moral consideration, and also the legal obligation. With this idea, right now, the people management front is helping or working in two phases. One is support to the employer or the organization, how to survive, how to come out with the situation. And second is how to help the employees, in this particular, to face this crisis situation. If somebody said that they can't hear me. My audio is not visible, not audible. Is it okay?
Yes, sir, we can hear you.
We can hear you.
We can hear you, sir.
Maybe a slightly weak signal, slightly weak audio signal, but we can still hear you. Carry on, please.
So in that case, if you talk about the employer side, right now the people management front is working in the employer side, the area of saving the cash. You all might be knowing the present problem is the liquidity problem. So how to manage the liquidity of the organization? The basic requirement is a saving of cash. So how to saving of cash or managing the liquidity is one of the most important area of the management and people management front to help the employers. It means how we can save cash in terms of the cost saving on deformation of payment. It may be in the administrative cost. It may be in the infrastructural cost. It may be in the non-essential activity cost. There are three things normally the people management is thinking. First, drill down the issue related to the non-essential activity cost. Number one. Number two is the administrative cost and the infrastructure cost. Each and everything to be analyzed, and how we can suspend some of the costs for the first quarter, shift it to the second quarter, or if it is not the third quarter, or if possible, to cut down permanently some of the costs to make the company little lighter in weight. Second part, innovative way of the reduction of the employee cost. As I'm talking to you, that is very important. No employer wants there will be a employee cut or employee reduction in this time. The reason is employee is always an important asset for the organization. In the organized sector, that is, I'm talking about in private organization. In private organization, already the number is very lean. Day by day, last 2-3 years, every company is having the exercise of downsizing people. So 90% companies already downsize. So they know that all the people who are working there, they have some role to play. It is very difficult for them just tomorrow to declare that I want to cut off this particular cost. But here, the innovative approach is important. Here, when I'm talking innovative means, suppose 100% employee matrix, maybe 30% people belongs to the leadership team or 20% leadership team. Maybe 70% or 60% in the front level. in the execution level. So the company already having exercise how to design such a organization structure where maximum discussion, heat, reduction, moderation will be the leadership team or the senior management team, where they can have some role to play in terms of the cost reduction, and minimum thing to be done in the grassroots level. Because right now we know that the life is very difficult, the trying times, so people or management wants to do less thing with the lower management. So HR people or the people management people are working in the area of suspension of the employee some of the costs, like in the PLI, variable pay, different allowances, and there are other things which can be suspended for some time, which can be shifted for some time, maybe in the first quarter, second quarter, or people may rethink, yes, some portion of the fixed pay can be considered in the variable pay, and the variable pay may be considered at the end of the year. So that is very important for the organization today, without demotivating people, without creating any panic in the organization, how you can restructure your entire CTC model. Your CTC part will design in such a way that there will be a benefit for a cash saving. Also, there is a positive note to the people of the organization. So HR people, IR people are working with that. This is basically right now, entire people management functions are busy with the top management team, senior management team, owners, promoters, about these three things: how to save cost, number one, how to restructure innovatively the employee structure. And in terms of the employees' perspective, same people front, same people management group are also working with the employer in terms of the employees' benefit. So the employees' perspective, the first thing is how to create an ambience and culture to keep the morale high. It is, I said to you before, that it is very critical thing. People has no idea about the impact of the entire disaster. So when we have no idea about the impact or what will happen in the near future, everybody is confused, starting from the chairman of a company to the shop, to the storekeepers, security guards. Everybody is in a dilemma, in a confused state, which is very, very difficult to somebody to prescribe with a confidence it will happen. Nobody can give guarantee that 17th May lockdown will be withdrawn. Nobody can give a guarantee whether from month of June everything will be okay. And we all know that private company has its buffer, as a window. We can manage the company 1 month, 2 months, 3 months, but there is a lot of things to be looked at. How long will this window be extended? For the purpose, the awareness to be percolated down each and every day. The people management people are through communication, verbal communication, or in a written communication, trying to create a culture to boost the morale, and continuous communication, and also bringing positivity into the system. And this positivity, not only for the organization, we are dividing the entire thing in 4 platforms: positivity and also the health of the mindset in individual level. Number 2, organizational level. Number 3, social level. And number 4, spiritual level. Each and every employee, by their HR people or by their mentor, to be trained in this particular situation, what should be his role in the individual level to tackle this crisis, what should be his role at an organizational level to tackle this crisis, what should be his role in the social level to tackle this crisis, and finally, what is his preparedness to handle this crisis spiritually. So if these 4 components can be properly calculated down to the people employees, then the health of the minds, and also the positivity in the system can be improved. These are the things where people management are very busy. Third point, implementation of the innovative method of engaging people. So when we are organizing a lot of innovative way of restructuring manpower, restructuring organizational structure, it may not be affected from today or month of May or month of June, but in near future, everybody is aware there will be a requirement of restructuring of organization, restructuring of the manpower. When the restructuring of manpower does not mean to reduce the number of manpower, it means there are 100 other options. It means alternate way of execution of work. Already 90% company started that work from home. So now the role is the people management people how to introduce it. Work from home does not mean for IT company. a brick and mortar industry, typical monologue company also can create a culture where their lower people can be work from home. Similarly, we should create administrative support, facility management to the people who are coming to the office in the lockdown period relaxation. Because my point is, as today is the 3rd of May, from tomorrow we have a third phase of relaxation of lockdown, which is started by the government on 20th of April. It has not no proper impact in the industry we have observed. Now the same thing is coming in from tomorrow with a little modification, more or less the circular of Minister of Home Affairs on 20th April, and today's circular 90% is saying when they're allowing an individual car to travel one more people. In place of 2 people, they can take 3 people. That's all. But my question is whether this type of relaxation in different zones, like green zone, red zone, or your orange zone, can be feasible. And the People Management Committee has a very important role. I am telling you, sir, as I'm part of the emergency service, essential service, a power industry, from the 24th of March, when we have initiated the lockdown in this country, from the very first day, we have our continuous work for the supply power in Asansol area. For a 1 minute, we can't afford for a shutdown, load shedding. For the purpose, we have managed our 27-28 substation meticulously. We have managed our load test center only by motivating people, educating people, and tell them this is the way of working. We have introduced shift duties. We have introduced scattered duties. We have also introduced, yes, this particular time, company will provide you transport, company will take care of your food, company will take care of your family because you are in the office, some requirement in the family. So company admin people are going to the family and trying to help it. If it's a medical emergency, we are providing support to the family so that the employee can work in the substation properly. So that is a very important role where the people management function or general management function should fail so that people at the end of the day are feel comfortable that my organizations are with me. I don't know what will happen after 3 months, whether my job will be there or not. It depends on the situation, uncertainty, everything. But today, I am a valuable asset. Company is considering me as a valuable asset, and they are doing everything pro thinking and helping to me. So this is very important for the people management function in this crisis time to create the infrastructure and administrative. Third point, we have to visit now each and every contract. I'm talking about the leadership team. I'm talking about the middle management team, whether particular role can be a full-time role or whether we can go for the change of the methodology. It is possible some role can be played on the retainership basis. It is possible somebody may be allowed to work for future from the residents and he can do 2-3 companies job at a time. The time has come when we have to revisit each and every contract, engagement contract with the people, senior people and middle people, and come for a solution that before going for any reduction of manpower, how we can revisit the present way of working. I have seen in my own organization, there are a lot of service support role, which can be extended in future or retainership mode. It is possible that particular person can work from home and do the job successfully. And in his other time, he can be useful for the other organization. So these type of things, the entire HR people of different organizations now, it is their day and night work, each and every micro planning. If there are 2,000 people in the organization and if there are 500 people leadership team or the management team, each and every management personnel to be reviewed by the HR department with proper introspection with their management and come with the blueprint. It is very, very important and it gives a positive vibration in the organization. They will think that management is not doing something by their own choice. Management is doing based on facts and figures, and we have some obligation for the business also. Because I'm talking about one thing. See, in the month of March, there are 10 days lockdown. So technically, I'm talking about the power sector. Power sector have lost their around 30-40% revenue in the first month. For the second month, some of the power sector, they lost their business for 50%, some at 60%, some 70%. I don't know what will happen in the month of May. Already we are in the 17th of June, 17th of May lockdown may continue. So in this lockdown period, in spite of the government circular to do all these things, technically it is not feasible. So as long as the entire economy is not open, no organization can tell you tell us that what should be my window. So if there is a revenue loss in the month of April, month of May, month of June, there will be a lot of repercussion. And whatever legal frame company is telling that we have to pay, we have to bear the cost, but how? Question of management is interested to pay. The second question is how to pay. If your revenue is not giving proper support to your OPEX, to your administrative cost, to your employee cost, how you will operate the business. I'm talking about my power sector. Power sector, government has said very clearly they cannot give a compensation of the particular revenue loss. So if there's a big revenue loss in power sector, then there's no industry operating. So ultimately, when there is a big revenue loss in the power sector, starting from 40% to 70%, the question is how long this window can be open. And so that's the reason I'm telling you from the very first slide, we have to preserve cash. Cash saving is the most important organization to save cash so that they can manage the liquidity in next 2-3 months. So for the purpose, it's a responsibility for the people management people, responsibility for the general management people to work with the promoters, work with the people and design a model so that there will be 2-3 months, if the crisis for 2-3 times, how to manage, considering there will be a substantial loss in revenue for 3-4 months. So that is the biggest challenge we are all facing, but we are optimistic. And again, I'm telling you, 99% organization, they are aware that the people in the grassroots level, people in the junior levels are mainly affected. So the entire design for the organizations, we are working from the top down. So first of all, restructuring, job restructuring, job cutting, job revisiting will happen in the leadership team, then will come down to the middle management, and finally with the grassroots level, if the situation required to come. Otherwise, company is optimistic. Company wants that the crisis will be over by 2-3 months. If the crisis is over, I'm very sure the next for the third quarter, this 2021, there will be proper working procedures. So my suggestion to all people here, right now, each and every company, people management from people to help the organization how to save your cash and try to manage your liquidity in 3 months, considering there will be a substantial revenue loss for next 3 months. With that idea, there are hundreds of innovative ways other than reduction of manpower. And that thing to be implemented where the suspension of pay, where the deferment of payment, where the non-essential service to be parked, where there are a lot of compliance issues can be handled differently. So the hundreds of ways, and HR people, people management people, IR people, along with trade union people sit together and try to cover the blueprint so that we are ready for the next 6 months if there is no revenue. So we should have a proper blueprint, considering next 4-5 months there'll be no revenue and how to do that. This is my response to Mr. Mukherjee's question to me, that as a senior man in the industry, what is the response? My response is this. This is a response from the people management front and also the business leadership who are managing the corporate business. Thank you.
Thank you. Thank you very much, Mr. Dasgupta. I think it was very, very interesting. And what I particularly liked about was the positivity in your approach. And that is so important in today's the sheer anxiety of the uncertainty of the near future. I also like the idea about the third dimension, which you talked about, the business obligation. I know we mentioned about legal and moral in respect of payment of wages, but there is also the business obligation in terms of from where does the money come? That's the very simple question.
Right.
And I particularly took note of, and I think it was very, very pertinent and very interesting when you talked about innovative engagement contracts or innovative engagement models, and to see how you can optimize your manpower deployment and productivity from a manpower perspective, from people management perspective, and thereby make your business even more competitive. And of course, your overall point about saving cash, which is absolutely imperative in these very, very difficult times. Thank you very much, Mr. Dasgupta, for that. I would now request Mr. Prabal Kumar Mukherjee, senior advocate, to tell us a bit more from a legal perspective. I would like you, Mr. Mukherjee, to respond to what Mr. Sarkar mentioned about the legality of the order of in absence of a national plan, so to speak, the order that was passed on 29th March, and Mr. Dasgupta's approach in terms of the business obligation and looking at new business engagement models and new engagement contracts. So I would like your opinion, your views on these two aspects. Along with that, I would also like you to shed some light typically on contract situations where you have fixed term contracts, where a principal employer outsources work to a contractor who in turn have multiple contracts in place with labor contractors. And how would you look at this scenario in this current context? What would be the obligations, etc., in discharging these contracts, honoring these contracts, or handling these contracts, so to speak? Finally, I would also like your view on this work from home, this new paradigm, this new idea of work from home. I know we are very familiar with the IT and the ITES business, and we can see how work from home can make a meaningful contribution and how it can all work. But there are jobs, there are work pieces that really cannot be done from home. So how do you look at this work from home concept? And to what all, apart from IT, ITES, you think employees can actually work from home? Does that actually work? Maybe you can shed some light, and I would then ask Mr. Panda later to shed some light on that as well. Over to you, Mr. Mukherjee.
Thank you, Mr. Mukherjee. Welcome all. Good afternoon. I'll answer Mr. Mukherjee's last question first. Say that what is work from home basically? Now, the work from home is that you are rendering your service from your home, and it depends upon the industry that you are serving. If it is a manufacturing industry where there are machines which are situated in your factories and all, it is not possible for an employee to work from home, except in the management level who can just give an advice over telephone or over the computer. Therefore, the work from home concept, so far as its legality is concerned, is rendering of service point of view to the employer. It can be from the home or in situ at the factory. Now, from the work from home is only feasible for certain industries, and it is not feasible for all types of industries. Now, generally the service industry, or as Mr. Dev Mukherjee has said, in the information technology industry or information technology service industry, this is feasible because many of the people can work from home because they have the appropriate apparatus at home, the computers and everything. Therefore, what they would have done otherwise in the office, they could have, maybe with their 80% capacity, could have done from home. Now, this concept of work from home was there initially also, maybe to a certain extent, the companies were utilizing that to a much lesser extent, allowing some of the employees who were incapable to travel or were medically incapable or advised to stay at home to render their services. Therefore, this concept of work from home now, which has gained the momentum because of the present situation, was always there. And it was always being rendered to the industry and the services appropriately in the appropriate cases. Now, coming back to the question that what will be the effect of the contracts which require a particular person to render certain services within a particular time, which have been effluxed due to the present COVID situation. Now, let us assume for the sake of argument that this particular contract requires that a particular work is to be done within a particular date without any clause for an extension. Now, there may be a contract which says that there can be an extension of the period of performance of a contract. Therefore, it presupposes two situations: a contract which cannot just go and perform beyond a particular date, a contract which can be extended. Now, there has been much of a discussion on the question of the law of force majeure and the frustration of contract. If we see Section 56 of the Contract Act, it talks about impossibility to perform. The impossibility to perform is a permanent impossibility. Now, in the present COVID situation, if it happens that a particular contract, which is capable of being continued and it can also be done after the period of this COVID lockdown is over, then we cannot take the benefit of Section 56 to say that this particular contract is impossible to be performed and therefore it becomes void. Therefore, Section 56 talks about a contract becoming void because of the impossibility to perform. Now, this COVID situation is a temporary situation, hopefully. And it is certainly a temporary situation. Now, in the event this particular situation continues for the time being, a contract which is supposed to be completed within the period when the lockdown is in force. Therefore, a person who is entitled to or obligated under the contract to perform, I jolly well say that because of the lockdown situation, it was impossible for me to perform. Therefore, the contract is void. Therefore, the person who has been mandated to complete a work within this period of COVID lockdown may jolly well take the plea of impossibility to perform under Section 56. But now take the event where a contract which can be also performed after this lockdown situation is over. In such situation, a person who is obligated under the contract, he or she cannot say that this particular contract has come to an end because it is impossible to perform. Therefore, this being the distinction in my mind about the force majeure clauses and the impossibility to perform under Section 56 of the Contract Act. So I come back, I'll just try to answer Mr. Dashgupta's discussion on the last. I'll come to the first, what Mr. Shorter has said, and I will keep my views on that. Now, the circulars have been issued by the government in the form of notification. Now that the notification dated 29th March, I'll just read for our purpose, the III is very important. I'll just read it in my own way because apart from that, it has been issued in exercise of the powers under Section 10(2)(l). What does it say? All the employers, be it in the industry or in the shops and commercial establishments, shall make payment of wages of their workers at their workplaces. Kindly mark this word, at their workplaces. This particular notification has been issued without due application of mine because it says that the payment of wages will be made at their workplaces on the due date without any deduction. I'll come to the ramification later, but so far as the phrase of this particular notification is concerned, I just draw your attention to this because you will get some cue what I mean to say later on. May I, with the permission of the chair, share the screen pertaining to this particular notification so that it can be read and understood what I mean to say. Sorry, I think the screen sharing has been disabled for me. But nevertheless, what I mean to say by reading this is that it shall make payment of wages of the workers at their workplaces. Now, if this wages are to be paid at the workplaces, then the question of lockdown says that the workers cannot come to their workplace. And until and unless they come to the workplace for the payment of wages, this particular notification clause says that only at that place they are required to be paid their wages. Now, the last page of this notification mandates that it is further directed that in case of violation of any of the above measures, the respective state and territory government shall take necessary action under the Act. The district magistrate, district commissioner, the senior superintendent of police, deputy commissioner will personally liable for implementation of the above directions and lockdown measures issued under the above mentioned orders. So therefore, this notification also directs that the authority should personally be liable for implementation of the direction. Now, if I take you to section 51B of this Disaster Management Act, which I'll read it for you, you will find that the opening word is without reasonable cause refuses to comply with any direction given by or on behalf of the central government. Now, the section 51B any person, not that it is directed to the department or any governmental organization, but to any person refuses to comply with any direction. Therefore, the direction is contained in the notification dated 29th March at clause 3, which we are concerned about the payment of wages without any deduction. And in the event the employer fails to pay this, then there is a penal clause which attracts a penalty of 1 year imprisonment under section 51B. Now, why I was saying that this particular notification was issued without application of mind was because of the reason that it says that yes, you have to pay the wages to the worker without any deduction on the due date, but at their workplaces. That is also very distinct in this particular clause. Now, if you see that the legislative intention of section 10 to L, the legislative intention of the section 10 to L, as Mr. Shorter was reading out to you, I'll just try to read it in my own way to say that section 10 to L has got two parts in it. The first one, it says that lay down guidelines for, comma, or give directions to, comma, then it says the concerned ministries or departments of the government of India, the state governments and the state authorities regarding the measures to be taken by them in response to any threatening disaster situation. Disaster. Now you see that 10 to L says lay down guideline or give directions to the concerned ministries, departments, government of India. But when you go back to section 51, which is a penalty clause, it talks about whoever. Therefore, this is the direction issued under section 10 to L.
Sorry, Mr. Mukherjee, to interrupt. Sorry to interrupt. I'm being a bit rude. If you could slightly condense. I mean, if you could finish in the next 3-4 minutes, please.
I'll try to do that.
Yeah.
I'll try to do that.
Thank you so much.
Yes. Now that what I was just trying to say is that because of the penal provision in section 51, now that the employers are obligated to comply with the notification dated 29th of March, which mandates them or directs them to make payment of the wages.
Are you there?
Yes, yes. Just a moment.
Yeah.
Now, so far as Mr. Dashgupta's contention is concerned, that is Dalgupta was telling about that how the industry is trying to mutate and adapt to the present situation, which is unprecedented, and there was no experience about that. Now, every industry or a business has to evolve. They have to evolve according to the situation that they face as of now. Now, for the purpose of sustenance, yes, it's very true that the cash reserve is very important. Now, for the cash reserve to be made, it is equally important that the cash flow is also to be there. Now, in the present circumstances, when there is no cash flow for the businesses, it's very difficult for them as of now to sustain. Not to which there might be in the future, there is a provision for a national disaster mitigation fund. There's a section for that, for creation of a fund. You never know with the fund, the government may at one point of time for the purpose of mitigation might give some tax ups or other benefits or schemes to the industry. But it might come in the future. But as of now, for the sustenance and to overcome this present situation or the period, it's for us or the businesses who should come forward, try to give their own bits and try to overcome the entire crisis scenario. Thank you all for your
Thank you. Thank you very much. Thank you very much, Mr. Mukherjee. Thank you very much, Mr. Mukherjee, for your response. May I now turn over to Mr. Prakash Panda. And Mr. Panda, before you, tell us about your views, and may I just request you to keep your observations within 5-7 minutes, if that's possible.
Yeah, absolutely.
And because we are running out of time, and I would like to know from you, in terms of your practical experience, if you can talk a little bit about how the current situation is impacting business on the ground, whether it's right across the spectrum, from the managerial, the contractual, the workmen, how that is happening, and how are you handling that situation? And if you can also throw some light as to how the unions and the organized workmen, how they are responding to this situation. Are they being cooperative, and how the situation is, in short, on the ground? Over to you, Mr. Panda.
Yeah. Thank you, thank you very much, Mr. Debkumar, and it's a pleasure to be part of this esteemed, panelist. Thank you, Someshji and Sukanya for keeping me part of this panel. I think this is a very, very unprecedented situation that we are into. This ongoing pandemic is having a very, very devastating impact across the country, across the world, and since it is something which we have never seen in our lifetime, there is no kind of case studies to refer as to how to deal with this. So you have to have a lot of scenario planning as to what is the best class scenario, what is the moderate scenario, what is the worst class scenario, and all organizations need to look at this aspect as to how you are dealing with this. And also to add to this, one thing which has happened which is a little unfortunate, is some of the organizations which are actually doing extremely well, highly profitable, stable, they have already announced some kind of cut in the salary across levels, and so what happens is this creates little panic. But how it is, there is some organizations which has done well in the past, there is a cash flow and there is a cash reserve is there. I think they need to take care this point of time, because their culture is going to be tested, how they are treating the employees during the crisis situation. And therefore, organizations is stable and profitable, even if this 2 months is going to be highly struggling for and they're not working, maybe or partially working, they need to take care of them in such a way, because every organization today.
Sorry, are you there? We can't hear you. I think Mr. Panda is not audible. Sukanya, are you there?
Sir, I'm calling him and finding it out. I think there's some bandwidth issues on his part. If we can continue and then again he can join.
I think we will we will progress with the thing, and then we will see if and when he joins in, right?
Yes, sir. Yes, sir.
You can address all the question if possible. You can take some question right now.
Yeah, before we come to Mr. Gautam Mitra, there was this thing about insurance which cropped up. Mr. Dashgupta, I think you wanted to take on that question about the insurance bit. What's your response?
Actually, this is a very important question which somebody is asking. The reason is, it is true the government has introduced a new scheme for the insurance and make it compulsory. So my concept of private company organization, now if you talk about the insurance, it is a part of the CTC, mostly in all the organization. We talk about the management people, basically whether it is a group insurance or it's an individual insurance, it's a part of the CTC. So normally 99.9% people in the organizations are covered in group insurance or in personal insurance paid by the company as a premium. And for the workman level, if you talk about the workman level, even to the contractors workman, before COVID also, we are from any organized sector, it's a responsibility to insist to the vendor that the employee should be covered under insurance. So that medical insurance part is already taken care before this COVID impact. Right now, maybe after this incident, we'll be more cautious. My experience has seen that 99% organization in corporate sector has taken care before. But it's a good point that government is now taken up. So I think who are 50% company was not done it before, they should do it. But my response is, in the management stuff is concerned, everything, as somebody says that personal insurance is part of that, very much. Because now 90% organizations who are not part of any group insurance, they are also reimbursing the premium of the personal insurance or the medical insurance as a result of the CTC breakup.
Right. Is Mr. Panda online?
He is trying to reconnect. I think let us continue with our question answer and then Jayanto sir, and if we can reconnect him, we will add him on.
I think since we are running out of time and we are all very eagerly waiting to hear Mr. Gautam Mitra, I think allow me to formally welcome Mr. Mitra, Mr. Gautam Mitra, because I know when I formally welcomed the other speakers, possibly he was not online. Anyway, good evening, sir. Nice to have you with us.
Good evening.
Yeah, and it's indeed, sorry, it's indeed a pleasure to have you with us. I'm given to understand that you are going to also deliver sort of a valedictory address, which was mentioned on the program. So I thought that, really. that was very interesting. But I'm going to request you to talk about the force majeure clause, which is now become very, very important in the sort of situational reality that we see around us in the wake of COVID-19. But the most important thing is a question that comes to my mind that I think what we would like to hear from you is some sort of a reality check in the context of this COVID-19 lockdown or force majeure clause. In other words, as to what extent can force majeure be stretched to get an exit from contractual performance? Rather, can people ride on the back of force majeure clause and avoid contractual obligations in the current lockdown situation? So that's going to be a very, very interesting scenario on which we would like your views. I would also like to know, I think we would all like to know a little bit more about this doctrine of frustration, which is captured in our Indian Contracts Act, and how that is going to work in the current situation. And finally, would also like to know from you, I know we have not mentioned about it, but your views on looking at mediation, or for that matter, even online mediation, as a preferred option for dispute resolution under these very, very unusual circumstances. Over to you, Mr. Gautam Mitra, for your views.
Thank you very much indeed. After listening to your list of subjects on which I am to say, I think this will take the whole of the evening. Not only the whole of the evening, perhaps a part of tomorrow also.
Right.
Because you have really opened up a chapter which is enormous. There has been a lot of literature in law, and this is a very practical question. But nonetheless, since you have put the question, I shall try and answer it as simply and as shortly as possible, because the time is up.
Yeah.
It's past 5:30. Therefore, my time is very short. Therefore, I shall try and be as short as possible.
Thank you.
What is force majeure? Let me put it this way: a valid contract may be ended by subsequent impossibility. The moment it becomes incapable of performance, but the events occurring must be such as to strike at the very basis of the contract, so as to frustrate the practical purpose of the contract. That is what is impossibility. That is what is force majeure. Now, Section 56 of the Contract Act has been mentioned by the previous speakers. I don't want to dilate on that. A lot of things, a lot of literature has grown up on that. Therefore, no point in my repeating all those. Shortly spoken, it says that an act which becomes impossible of performance may render the contract void. But it must be remembered that such impossibility does not mean commercial impossibility. For example, I am giving the example from a Supreme Court decision. For example, a turn of events which the parties did not at all anticipate when they made a contract. A wholly abnormal rise or fall in prices, for example. A sudden depreciation of currency. An unexpected obstacle to the execution, or similar such situations. It must be remembered that there is no general liberty reserved to the courts to absolve a party from the liability to perform his part of the contract merely because of some uncontemplated turn of events has happened, which has rendered the performance of the contract onerous or difficult. Now, apply this principle to the facts of our instant situation. By reason of this COVID-19, many of the contracts which were in the offing or which were in the process of execution came to a grinding halt. Now, what is the consequence of that? Can the party who was performing the contract and who is being prevented from performing any further, can he turn around and tell the other party, the contracting party, that look, the contract has become impossible of performance, therefore I will not perform it? Now, this is a question, this is a vexed question. It will depend upon situation. Now, in a situation like ours, the one that we are passing through, we all sincerely hope that it's a temporary phase. It is not a phase which is going to permanently affect our economy. If it is not, then the contract may be kept in a state of suspended animation. I repeat again, it could be kept in a state of suspended animation. What is the meaning of that? This means that the contracting parties will say that, look, this is the half time. We resume our play only after the situation has normalized. Let us not say that the contract has snapped or that the performance of the subsequent part of the contract has become impossible. Now, in that context, you have to read the Disaster Management Act. In my very humble submission, we should not think that this is the end of the world. I congratulate Mr. Dasgupta for his brilliant, absolutely brilliant resume of the submissions that he had made. And I fully agree with him that it is a time to rethink, to readjust ourselves, to consider that the situation which has arisen, I am not pessimist by nature. I am an optimist. I think the situation will come to an end. If not today, tomorrow. If not tomorrow, day after tomorrow. But it will come to an end. And as Mr. Dasgupta has rightly pointed out, that it is a time for adjustment. People will have to sit together. We'll have to restructure. We'll have to innovate. And I'm really quoting his terms, the language he has used, and rightly so, that this is a case of restructuring and innovation. So in a situation like that, I say that force majeure clause rendering the contract impossibility of performance, that should not be there. I do not know. Am I audible?
Yes, you are.
Yes.
Yeah.
So this is
Yes,
one
sir,
aspect.
you're audible.
Sorry.
You're audible.
Yeah, you are audible. Yeah.
Okay,
Carry
then
on,
I
sir.
can. So then I continue.
Yeah.
So this is the one aspect of the question of force majeure. The second aspect is this, that when we say, for example, let us take an example, that a contract is in the process of implementation. It has been done halfway. Now in the middle, suddenly this disaster has taken place. Result is this, that a contract which was in the process of being implemented has come to a grinding halt. The workers have run away. The management are quarantined. The close down has rendered the entire thing, it had brought the entire thing to a grinding halt. In a situation like this, what should be the approach? As I said, I am an optimist. I think that the situation will come to an end sometimes in the future. In the meantime, it is the time for the two parties to adjust their own affairs. In order to adjust their own affair, as Mr. Dasgupta has suggested, and very rightly so, that this should be done at arm's length, each party taking the other party into confidence and then sorting out the problems. But never, I do not say that the contract should be brought to an end. Never say die. Never say die is the principle which should be followed in the facts of the instant case. The situation is such that we should not turn around and say, we should not throw in the towel and say that this is the end of the situation. Now, I come to the next aspect of the matter. I was looking into what do you call these regulations, orders, and whatever it is. Which have been published. Now, you see first of all, say 29th March 2020, which has been issued by the Ministry of Home Affairs, Government of India, under the signature of the Home Secretary in his capacity as the chairperson, National Executive Committee. The reason given there, movement of a large number of migrants. And reason, to mitigate the hardship of the migrant workers and for effective implementation of lockdown measures. Now, these measures have been brought in by and under this Disaster Management Act of 2005. I do not believe that the government has invoked its powers under this particular act for nothing. We are passing through a grave crisis, through a critical situation. A grave crisis is facing the country, the world is facing this type of crisis. In a situation like this, it is well nigh impossible to carry on your activities as you had been doing earlier in the past. It is not possible. So if it is not possible, then what do? You will have to bring in some kind of a regulation, some kind of a restriction, some kind of regulatory measures, which will, so to say, guide your actions for the future. Keeping that in mind only, these regulations have been brought. And these regulations have been brought in terms of the Disaster Management Act. If you see the Disaster Management Act, what is a disaster? First of all, see what is a disaster. A disaster is a catastrophe, mishap, calamity, or grave occurrence in any area arising from natural or man-made causes or by accident or negligence, which results in substantial loss of life or human suffering or damage to and destruction of property or damage to or degradation of environment, and is of such nature or magnitude as to be beyond the coping capacity of the community of the affected area. Now, I read it out for the purpose of only impressing upon you, sir, the significance of the happenings today. You apply this particular definition of disaster to the facts of what is happening today. And you can have no doubt that we are passing through a disastrous situation, a calamitous situation. Now, if that is so, I am proceeding on that premise. If that is so, then disaster management is required. Now, how do you do it? One, prevention of danger or threat of any disaster. Then mitigation or reduction of any risk of any disaster. And then ultimately, the eighth, rehabilitation and reconstruction. Now, who has been entrusted with this particular duty? The duty has been entrusted on absolutely the highest authority that you can imagine, which has been constituted under this particular act. First is National Disaster Management Authority, of which the chairman is the Prime Minister of India. Then the State Disaster Management Authority, of which the chairman is the Chief Minister of the state. And thirdly, the District Management Authorities, of which the chairman are the district magistrates. So high-powered committee has been constituted for the purpose of looking after this. Now, these people have been entrusted by whom? By the parliament. Who is the parliament? It is you and I. It is us. We have entrusted this particular duty, this particular obligation with a set of people who we think are the persons who will be able to deal with these matters properly. Now, these people have sat together and formulated these regulations, which have come out, some in the form of order, some in the form of regulation, some in the form of memos, whatever it is. This 29th March 2020 regulation, that has been in the name of the highest authority, the Ministry of Home Affairs, under the signature of the Home Secretary, who has been made the chairman of the committee, this National Executive Committee, which has been entrusted, which has been this particular power of the highest authority has been delegated to National Executive Committee under Section 10. Can you look at Section 10? Section 10, National Executive Committee, with the constitution of which is in Section 8, you will find that the executive committee will be constituted by these people. And this particular committee has framed these regulations. And when these regulations have been framed, what have they said? What have they kept in mind? They have kept in mind the fact of movement of a large number of migrants to mitigate their hardship. Our people, our citizens, how can we forget them? For effective implementation of the lockdown measures which has been accepted by the whole world as the only way I say, you can avoid this particular deadly disease spreading all over. Now they have, in order to mitigate the hardship of the migrant workers and for effective implementation of the lockdown measure, they have formulated this. Now they, in course of this, they have said that wherever the workers, including migrants, are living in the rented accommodation, the landlord of the property shall not demand payment of rent for a period of 1 month. What's wrong with that? Persons who have got the capital, who have got the wealth, they have been directed by the government that do this small sacrifice for your own brethren who are suffering, migrating from one area to another area, who had gone over there for the purpose of earning their livelihood. Now they are coming back. Please, for their sake, you excuse them 1 month's time. Nothing wrong. Then, what do they say? Again, shall make payment, the III, all employees, be it in the industry or in the shops and commercial establishment, shall make payment of wages of their workers at their workplaces on the due date, without any deduction for the period their establishments under closure during lockdown. See, what the government is saying is this, that lockdown has taken place. It is not your fault, not the employer's fault. Neither it is the employee's fault. But nonetheless, due to some supervening happenings, these establishments had been closed down for the time being. Again, I say suspended animation. So what they say is, you have got the capital, you have got the money for the time being. We don't say that for all times to come that you will have to do so. During this period, you, without any deduction, you pay their wages. Why? Because in order to make them survive. Perhaps the government went on the basis, proceeded on the basis, assumed that insofar as the employers are concerned, they have got the capital in their hand, they have got the amounts in their hand for the purpose of sustenance. But the poor workers who had been working, earning their daily wages, they won't be able to survive. So pay them their salary. The government had also come forward. I put into the account of each of these workers a sum of ₹1,000 for this month, so that they can survive. Again, the question arises as to whether this is justified or not. I concede that if you test these things on the basis of strict contractual provisions, on the basis of the strict law of contract, strict law of employment, Payment of Wages Act, if you apply this, I will not be able to sustain this. But then, extreme situation requires extreme measures. And these extreme measures are these. Now, you see, the thing is this, it has got also, sorry, can I, am I?
Yes, carry on, yep.
I'm sorry, I'm taking some time, but I'm trying to cut short as much as possible. I say that it has got constitutional angle. Please don't forget that. Constitution, which is the Bible in our hand, that says that Article 19 says this, protection of certain rights regarding freedom. And G is this, 1G, to practice any profession or to carry on any occupation, trade or business. You have got every Indian citizen every Indian citizen has got the right to carry on any occupation, trade, or business without any interruption. And the same thing has been again stated in Article 301. In Article 301, it says freedom of trade, commerce, and intercourse. And it says that subject to the other provisions of this part, trade, commerce, and intercourse throughout the territory of India shall be free. Now you can question, you say that if the Constitution has given us the right to carry on any profession, occupation, trade, or business, or intercourse without any obstruction and freely, then how can you impose these restrictions like this? Now, answer is very simple. Answer is that these can't be totally unrestricted rights. Sub-article 6 of Article 19 says so. It says that in the interest of general public, reasonable restrictions can be imposed. I'm saying again, repeating again, that in the interest of general public, reasonable restrictions can be imposed. Similarly, in Article 302, the power has been given. The Parliament may by law impose such restrictions on the freedom of trade, commerce, or intercourse between one state and another, or within any part of the territory of India, as may be required in the public interest. Now, this is the last part of my submission. I don't want to protract I say that the Constitution has given you the power, the liberty, the freedom to carry on your business, your trade, and your occupation. But at the same time, the Constitution has entrusted the Parliament with the right to impose restriction, reasonable restriction, as may be required in public interest. Now, I ask you, gentlemen, this question. Can you keep your hand on your heart and say that what the government is doing today is not in public interest? Yes, I concede that in the process, your liberty, your freedom has been curtailed. The contractual provisions are sought to be, so to say, kept in abeyance, kept in suspended animation. But is the government entitled to this? Is the Parliament entitled to do that? I say that look at the provisions of the Constitution which you yourself have given to yourselves. That Constitution is saying that even though you have been given the freedom to carry on any occupation, trade, or business, but nonetheless, in public interest, reasonable restriction can be imposed. I say today, gentlemen, you consider the entire aspect of this matter in the light of public interest. And if you think that way, then you will find your answer. I am sure that all of us will come to the same answer. And that is why I congratulate Mr. Dasgupta for his submissions. What he said is this: he did not derogate, he did not, so to say, condemn what has been done. But he said that in the facts and circumstances of the case, the employers and the employees will have to come together and find a solution. This solution is absolutely essential for the purpose of survival of our country. Today, I am thankful to Bengal Chamber of Commerce for having brought this subject before the public. It is necessary because people must know what is right and what is wrong. Yes, from the point of view of a lawyer, there are so many loopholes we can find out. But is this the time to find loopholes? Or is it the time to try and sustain each other, sustain ourselves? Bengal Chamber of Commerce is an institution which does public good. It is an institution which speaks on behalf of the industry. But industry is not a heartless machine. Industry consists of employers, employees, the workers and their bosses. And I do not think either of them is unreasonable. So I will conclude my submission by saying that today I am thankful to BCCI for having invited me and giving me this opportunity to express myself. I'm glad that I have been able to express myself. And I say, again, I repeat myself, pardon me for doing so. I repeat myself, today time has come when we, all of us, join together and for the purpose of defeating a common enemy. And only way we can do that is to be reasonable with each other, with each other's dealings with each other. And so long as we can do that, we'll be able to proceed forward. Otherwise, disaster will strike all of us. Thank you, gentlemen.
Thank you very much, Mr. Mitra, and compliments to you. You have raised the discourse to another level, which I think, of course, it's worthy of you and good for all of us. That one has to take a humane view of the whole situation and take a holistic view, and one has to look at public interest as the main objective for which all this exercise is being done. And the idea of never say die was something that went down very well with me. So both Mr. Dasgupta and you have struck very positive notes, which establishes the point that we shall certainly sail through this crisis, and whatever in our own small way we can do to help tide over this crisis and take care of the large multitude of people around us, our communities and our fellow countrymen, we should play our own little part and help in the process. Thank you very much, sir, for a really impassioned speech. It was really very great. I think we have really run out of time. May I now request Mr. Paritosh Sinha, the co-chair of the Legal Committee, to formally close the session with a vote of thanks. Is Mr. Sinha there?
Yes, sir, he is there.
Yeah. Sir, if you could please formally close the session.
I'm not sure if I'm audible.
Yes, you are.
Yes, sir, you are audible.
Respected Mr. Mitra, Mr. Shamal Sarkar, Mr. Prabal Mukherjee, Mr. Shomesh Dasgupta, Mr. Prakash Panda, it's my absolute privilege and pleasure to offer my vote of thanks on behalf of the Bengal Chamber of Commerce. It was indeed a very, very enriching experience for all of us. I'm grateful that you could take time out of your busy schedule and bless us with your presence. And I'm particularly grateful to Mr. Gautam Mitra for his impassioned speech and the hope that he gives all of us. That is something we need to look forward to in such difficult times. Thank you, everyone. Have a very good evening.
Thank you. I think we can all sign off. Stay safe, stay well.
Thank you.
Thank you.
Thank you, sir.